Good morning also from my side to everybody. We three are quite happy to be here today. I think it's the best just to start with my presentation because it's very close to the presentation already given before, and I would like to focus on the principles of successful patent drafting. And my opinion is the best way or the most successful way to result in a good patent application is a very good cooperation between the inventors and the patent attorney who has to draft the application. And there are three topics I would like to concentrate today, and the first one, most important one, is the invention disclosure form you have to file in and to submit at the respective department. And then you will see how the information from this invention disclosure form will result in some topics, some information in drafting of the claims and in the drafting of the description. And how does everything start? Well, you work hardly, we work hard in the labs and prepare an invention. So you receive first results, you receive further results, and finally you have an impression what might be the best solution and what is the scope of the invention you can claim. And of course this best solution is dependent, for example, on the customer or market demands. If you have a knowledge in which field your invention can be used. Of course, costs are important for the best solution if there are any competitors, and of course also an important question is whether your invention prepared in a lab is practicable for use in an industrial range. And if you provide the invention disclosure form and to best assist the patent lawyer who then draft the patent application, it is very helpful to answer some questions. And the first general question, which is very important for the patent attorney, is in which technological area, in which field is your invention? And this might be, for example, a polymerization process, which is of course a very general information, or a catalyst development, a new use of a product or whatever. And as an inventor, you have the best knowledge of your invention, and of course, so you might think, what is the real core of the invention? Is it a new product you have developed? Is it a new process, or is it a new use of a compound? And this information is quite important because there are only three claim categories you can claim in a patent application, which are product claims, process claims, or use claims. And so this information already helps the patent attorney to better understand your invention. The next question is, this question is also related to the general technical area. What is the prior art? What is the starting point of your invention? What is known? What is the general basis, the general knowledge? And is there, for example, one document which is very close to your invention, which may be used as a starting point to finally reach your invention? And if you are aware of such a closest prior art document, this is usually a document which has, of course, then the most features in common with your invention. And another question, of course, if you are aware of any prior art, are there any disadvantages of the prior art? So any disadvantages, of course, also of the closest prior art. And this then, of course, results also in the question, what are the advantages or the improvements of your invention compared to that prior art? So it is very helpful for the patent attorney to know your opinion regarding the differences between your invention and the prior art. The question may then be, what is the difference? So, for the field of patents, a difference may be defined in a different way than in usual life. And I would like to give you 2 examples what can be a difference in patent law and what is not a difference. And this example, the first example is, for example, a prior art related to a catalyst composition with 3 components, A, B, and C. This is very general. And your invention is also a catalyst composition, having also the 3 components known from the prior art, but having additionally a 4th component, for example, an additional metal or whatever. And by use of this 4th element, you can demonstrate that the catalyst results in an improved selectivity, for example. So this is a clear difference, and this difference may be the basis then for filing and for drafting the patent application. So a difference, the answer for a difference here is yes. In another example, the prior art discloses a polymerization process, also with a catalyst, and it's essential for that process to be carried out at a temperature range from, for example, 50 to 150 degrees of Celsius. And now your new development is the identical polymerization process, but conducted at a temperature of, let's say, 100 degrees of Celsius. So you easily see your chosen temperature range is within the range of the prior art, and the answer, if there is a difference here, is no. Then back to the questions. You have to consider what is the best solution of your invention and gives the best results. You can imagine there are so many parameters you can probably choose for your invention. Some parameters may be absolutely necessary, otherwise your invention will not work. And there may be other parameters or other features which have some benefit but which are not absolutely necessary for your invention to be carried out. And this is then very helpful for the patent attorney to have a structure which features are absolutely necessary, which are only an option. Methanol or butanol will fall under the scope of protection, and this simply easily shows you that this is an important question. Other examples, maybe for example, you have developed a polycondensation process for polyethylene terephthalate, and you may ask, well, probably this process may be useful also for other esters. Or another last example is you have developed a process which is the best solution. Results are achieved at a temperature of 80 degrees. And you can ask, well, may I broaden this temperature range where this process can be carried out? You should provide in your invention disclosure, if possible, a number of examples to illustrate how your invention works. And examples should be preferably in a range between the best solution and the minimum solution. The minimum solution here shall be meant as having only the absolutely necessary features to carry out your invention. And then there should be also examples having additional, only optional features, so to provide the patent attorney with some information that the invention is indeed or can be carried out in the whole range you have stated before. If you have generalized some features, you should provide some examples, if possible, to cover the full range. Then if you have finished the invention disclosure and the university agrees to draft and file a patent application, you will probably very well recognize the information you have provided in your invention disclosure form. You will see every information, hopefully at least, in the claims and in the description. So it's then the task of the patent attorney to draft the patent application, and the most important thing of a patent application are the claims, especially the independent claims. The independent claims should relate to the minimum solution. That means it shall only disclose the features which are absolutely necessary. And in the subclaims, which are then dependent on such independent claims, the optional or preferred features should be stated. And somewhere in the subclaims, usually, you will find the best solution, so the solution which provides the best